Hello, my name is Tom Bailey, and with my friend Paul Fox, we're here to talk to you today about the basics and introduction to the Educator Discipline Act. We're both retired teachers, and we still have contact with the schools. I was a substitute teacher at two local Allegheny County school districts this past school year, and Paul, former music educator, still helps out with his band, the marching band, as an assistant. So we're still talking to teachers, we're still talking with kids, and we know that the last several years have been difficult. Not only dealing with the fear of COVID, of contracting COVID, but then doing the virtual learning, where many teachers are hands-on and they want to be around their kids and hear their kids and listen to their kids, but it's difficult when they're on the other side of a computer. And now with the classes that were back in session this past school year, I hear of attention issues. The phone guy I taught with for a number of years is very frustrated about trying to police the phones. And another one is with the lack of money in many districts, which brought up the William Penn court case that we'll talk about just briefly. But we also know that professional ethics is a professional development that's coming down the pike. In fact, it's going to get started this coming school year. And Paul and I present an Act 48 course for educators on professional ethics. And we also present a PIL course dealing with the ethical codes for school and system leaders. So what we've done is we've set up a series of videos where we introduce the topics that are in this professional ethics series. So let me show you some of these presentations that we've done, and then I'm going to keep going with them through July. So let me show you this.
Tuesday afternoons.
This is the series that we have done, and just today's the last day of this set. But we started off with the William Penn court case. And if you haven't heard of the William Penn court case, 9 years ago, 2014, William Penn School District, which is out in Delaware County, and 5 other school districts sued the Pennsylvania Department of Education, the governor at the time, Governor Wolf, the Secretary of PDE, claiming that the state legislature was not funding the school districts across our Commonwealth in an equitable manner. And just in February, President Judge Jubileer agreed with the school districts and found that the state has been violating the Pennsylvania Constitution in the way that it has been passing out money in the state funding formula. Now, 2 of the members that were the defendants argued and said that her decision wasn't correct, and I've not yet seen whether or not they're going to appeal. They could appeal the case to the Pennsylvania Supreme Court. So that was the focus of our first session back in late May. But then these next 4 are for the professional development that's coming up on professional ethics. Sorry about the use of the word profession repeatedly. There's 4 key topics. One is what's called the Model Code of Ethics for Educators. And if you have not heard about this, you will, because all across the country, educators are being urged and forced to consider and discuss ethical issues. This is the session that Paul does. Also, everybody here in Pennsylvania has a code of conduct. All the educators must follow the PA Code of Professional Practice and Conduct. In this session, we looked at that, and you need to know you can be disciplined if you violate this code. The 4th or the 3rd item was the Pennsylvania Professional Standards and Practices Commission. This is the organization made up, over half of them are teachers, or just around half are teachers. And they listen to cases where an educator has been charged with misconduct, and they're the ones that decide if he or she is going to be disciplined. Today's session, though, is based on the Educator Discipline Act, the actual statute passed by the General Assembly in Harrisburg as to what teachers can and cannot do, or they could lose their teaching certificate. So let's get started. The agenda for today. We're going to look at the background of the Educator Discipline Act. And then for me, it helps to break down that there's two different ways an educator could be disciplined in Pennsylvania. One is through a local discipline, through their LEA, and the other is through a state discipline system. And that's the one we're speaking about today with this Educator Discipline Act. We're going to look at several sections of the Educator Discipline Act, and I'll show you how to reach an online version that's free. And then we're going to finish with one court case where a Pennsylvania educator was charged with misconduct, and she was able, by the decision of the court and the commission, to change the Educator Discipline Act because the court did not like the way the commission responded to her case. So that's one option. And then we'll look and take your questions and comments. Briefly, in 1973, the General Assembly passed the Educator Discipline Act. This is the only one I'm going to read verbatim so I get it right. And this act was intended to relate to certification of teachers in the public schools of the Commonwealth and to create a Professional Standards and Practices Commission. So roughly 50 years ago, the Educator Discipline Act was put on paper, and it's been referred to many, many times since, and it also started the commission. So in many ways, it was quite significant. If an educator has a complaint filed against him or her, or if there is an issue that is brought up by the school district, they're going to be largely handled in two different ways. One is if it's initiated by charges at the local level, there often be what's called a Loudermill hearing. And Loudermill is a U.S. Supreme Court case where a person that worked for a school district was disciplined, but never had a chance to explain himself. So by a U.S. Supreme Court, there now has to be a Loudermill hearing to discuss it. But I think you would likely have heard of a public school code in 1949. That's the statute that sets forth and discusses local discipline. There will be a hearing in front of the LEA, the board of directors, and the possible sanction is that the educator could have their employment contract terminated by the local school district or IU or Career and Technical Center. But I'd like you to know that the public school code is the one that sets forth the hearing procedure for local discipline. Now, it's a little different if it's a complaint process set up under the Educator Discipline Act. And this is if there is an allegation of violating and possibly losing your state certification. The certification could be sanctioned, or you could lose it altogether with what's called revocation. But the decision in this case is going to be made by this commission, Professional Standards and Practices Commission, not the LEA's board of directors. And then the process we're going to look at later on is actually the process set up by the Educator Discipline Act. A couple of the sections, just to give you a preview, we're going to look at the definition section. And very briefly, the certifications that we all had when we were teaching in the public schools. And then we're going to skip the section dealing with the commission because we actually went over that last week. This is the most important part, in my opinion. There are 5 or 6 different ways that an educator misconduct complaint could be filed against an educator. And we're going to look at those complaints and the process PDE follows to investigate the complaint. Mandatory reporting, I imagine most of you have heard as far as Act 126. Then there's going to be discipline for criminal offenses. And there's also what's called imposition of discipline for additional grounds. And you'll see many of those are not used as much today as they were in the past, but a couple of them have been. And founded reports is where there's the child welfare system, separate from public schools, but is tied with the public schools. And then reciprocal discipline. To close out, we're going to look at what school entities have to do if there is a notice of charge filed, and then the department. They could take action and begin the process of having the case heard by the commission, and then there's a hearing. This is the Pennsylvania Professional Standards and Practices Commission website. And in many ways, it's a great place to start if you have questions about anything going on with education, and definitely for alleged misconduct. It is linked to the PDE website. In fact, if you get to the PDE website, you look down, you'll see Governor Shapiro and then the acting secretary, but you'll also see a link right to the commission's website. So my recommendation is to see the Educator Discipline Act. I would go here to what's called statutes, regulations, and forms. And here you can see several documents. One's the Code of Professional Practice, free version of that. Here's the Educator Discipline Act itself. And then there's the Model Code of Ethics. But for today, we're going to go to the Educator Discipline Act. It's going to take us to a link. There's the code. Compared to many other statutes, this is a pretty clean copy. I think it's fairly easy to follow. Sometimes I even get messed up directing myself through here. So these are all the sections. There's 19 sections in the Act. And we're going to dive into what I think are some key terms in the definition section. So here's a certificate defined. And I didn't even know what supervisors did as far as their certificate. They don't have the same as what the teachers do, but it is defined and there's references there. And then the cyber or charter school definitions. And if you've taken a Act 126 training recently, you recognize the Chief Administrative Officer. Sorry about that. Chief School Administrator. I would direct your attention to the definition of child, because it's referred to later in the Educator Discipline Act and has nothing to do with being a student. It's any individual less than 18 years of age. And having been, as I mentioned, a substitute teacher through a subservice, the subservice is a good example of what a contracted educational provider is. They literally had a contract with the school district. And then I was a contracted educational provider staff member. So some of these terms come up. All right, major one here, in my opinion, is the definition of discipline. Should you be found to be liable of misconduct, these are possible sanctions you could be imposed. First, a private reprimand is a writing by the commission, but it's not made public. A public reprimand is, and it's put on their website. Suspension, temporary, limited amount of loss of your certificate, and the revocation is a permanent revocation of a certificate, but it could be your ability to teach could be reinstated. And so revocation in many instances may have an end date. And then surrender is where you choose to voluntarily give up your certificate and the commission has not taken it from you. Supplemental sanctions, I ask you to hold on to this concept I'd like to show it to you later. There's some possibilities for remedies that a lot of educators are not aware of that are called supplemental sanctions. There's the revocation definition. Okay, two very important but very unfortunate terms. Sexual abuse or exploitation shall have the meaning given to it by an entire separate statute dealing with child protective services, but they use the exact same phrase. So if you've ever seen these two terms side by side, people say, why? It's because they refer to different statutes. And here's sexual misconduct for the educators. And I'm going to take the time so that you can see how the commission defines sexual misconduct. So I mean any act, including but not limited to any verbal, nonverbal, written, or electronic communication or physical activity directed toward or with a child or a student, regardless of the age of the child or student, that is designed to establish a romantic or sexual relationship with a child or student. Such prohibitive acts include, but are not limited to. You can see these for yourself. So this is a relatively new section. Sexual misconduct would include all of these. Huh. All right, here's the supplemental sanctions. As a type of sanction imposed shall mean prior to public disciplinary sanctions that focus on remediation or restitution, including, but not limited to, fees, fines, prescribed coursework, evaluations, treatment plans, impaired educator programs, and other corrective action plans. So if you ever hear somebody say they're going to be disciplined by the commission, they may want to take advantage of these and help themselves. All right. Here's the detail of the certification. And we're going to pass by the section on the commission. But it is there. If you want to, it is there. I believe there's 3 or 4 pages of it. Okay, this is the section I would ask you to follow along with. And just remember it's here if you'd like to look. So the filing of an educator misconduct complaint starts this process, in that they will then investigate the complaint and see if they find there to be merit to it. So section E here, upon receipt of a complaint, the department shall promptly review it and all their complaints and information relating to the educator. Now, if the department determines a probable cause exists, they're going to provide notice to the educator, the complainant, and please look here, the current and former school entity in which the educator is or was employed. So they then request that LEA essentially follow up on any investigation they did or any discipline there, and then report that to the commission so that they can know what the status of the lower level discipline was. Okay, mandatory reporting. This is all the Act 126 material. Please notice here, any educator who has been arrested or indicted, now that just means you're charged with it, hasn't been convicted, but then the term convicted of is graded a misdemeanor or felony. Those people have to be, their names need to be turned into PDE. Please look here for letter D. When I was teaching, this is an issue many of us were not sure what to do with. If you know of any action, inaction, or conduct which constitutes sexual abuse or exploitation or sexual misconduct, those 2 terms we looked at, under this act, you shall file a mandatory report with the department, and you shall report such misconduct to your chief school administrator and immediate supervisor. The report shall be filed within 15 days of the discovery. So there's 3 affirmative actions you have to take, or you could be disciplined for not following the Educator Discipline Act. All right, these are not as well known. The commission shall direct the department to immediately suspend the certificate of persons that are charged with certain crimes under the Public School Code of 1949. There's no discretion there. Largely, this is based upon Jerry Sandusky with the allegations and his conviction for sexual assault. And the state government felt that Penn State wrongfully kept that information from PDE. So now it's obligatory.
No clauses of confidentiality for staff.
Yes, that's also mentioned, that the school district, or in this case, the college, can't make a confidential deal with their former employee. All right, this is the one that I found is the least understood. Another type of educator misconduct complaint that can be filed is called imposition of discipline on additional grounds. So in the public school code, many of the offenses in the public school code are based upon the allegation of immorality, incompetency, intemperance, cruelty, and negligence. Some of these terms people rarely use anymore, but just basically, the immorality is feeling that you have violated not only your moral code, but the code of ethics for teachers. Incompetency meaning that you don't know enough in your subject area. Intemperance means that you can fly off the handle at any moment. Short fuse. Cruelty, that you would deliberately pursue against a student or another staff member, knowing that they were suffering by your actions, but you continued to do it. And in negligence, some action that you took that you did not comply with a duty that you had. Okay, here's the sexual misconduct and sexual abuse or exploitation that I mentioned earlier. And if you are not aware, if you would violate our code of professional practice and conduct, here is where you can specifically be punished by the commission. Okay, founded reports. Here's the reference again to Child Protective Services. Many of us have taught for a number of years and had a variety of circumstances. A year or two before I retired, one of our young teachers was just gone. And I asked about him, and there had been an allegation of favoritism and sexual relations with a student. It was fully investigated by the local district attorney and the PDE, totally exonerated. But he went through a very, very difficult time because the Child Protective Services statute and the educator misconduct allegations. And reciprocal discipline is the last one as far as a type of educator misconduct. Reciprocal just means like as. And if I was charged with endangering or corrupting the morals of a minor here in Pennsylvania, that would be a problem if I was convicted. And so if I am convicted of it in Maryland, I can't say, it doesn't apply to me because it happened in another state. Reciprocal means that if it happens in any other state or territory or nation, Pennsylvania can still impose a penalty if the charge itself would be a violation here in PA. Okay, just wanted you to see this. If the LEA gets a notice from PDE that they're investigating allegations of misconduct, they have to provide and do their own investigation. And they have to comply with PDE's request and then make that available within 90 days. And this is the last one then, that as far as just trying to give you an outline, should should PDE find that the educator has, they believe, committed a violation, they're going to what's called initiate a formal adjudicatory hearing process with the filing of charges with the commission. And once that happens, the defendant educator gets a copy of it, and then the clock starts ticking. And if you look here, the clock starts with, you have 30 days to respond to the notice of charges itself, and then other items happen largely in a sequence. But that only happens if notice of charges are filed and that the case is transferred to the commission. If the case does go to the commission, it'll largely follow a sequence of events that happened in the hearing. I'm going to review that, and then I'm just going to go through a fact scenario that we use in our professional developments, where a case is very similar to what we talked about as far as someone being charged with a crime. Should an educator misconduct complaint be filed, it is treated the same way as a mandatory reporter, and that PDE does the investigation, and only if they find that there's probable cause for it will they then send it to the commission. So I just wanted you to see that these two types of complaints are treated in the same manner by PDE. And this is a very quick chart. I'm just going to move up here to where there's a notice of charges filed. Once the educator files an answer, and they could say they agree and they don't want a hearing, but if they disagree, here's the provision for a hearing. Before the hearing, you would meet with the hearing examiner. It's not a trial, there's no jury, it's not even a public proceeding, it's closed, but you do have the right to meet, or your attorney would have the right to meet with the hearing examiner and the PDE attorney to discover what evidence is available and if they'd be willing to settle the case. Then there is a hearing. If there's no settlement, PDE presents witnesses, direct and cross-examination. You would be able to present witnesses, and those would include expert witnesses. Then the hearing examiner writes up what he or she thinks is the findings of facts and conclusions of law. And if you disagree with that, you can file what are called exceptions and briefs, but the commission will have the final say, and they impose any sanction, but it would largely be based upon the hearing examiner's decision. There is a possibility of appeal to Commonwealth Court. They do not have to hear your case. If they do accept the case, then it goes through the process of briefs and arguments again to the court. And sometimes the Commonwealth Court writes an opinion that reverses the Professional Standards and Practices Commission, and sometimes they agree totally with it.
But it doesn't have to accept the appeal. Commonwealth
It does
Court
not have to
doesn't
accept the appeal. Yes, there's very few types of appeal that an appellate court would have to hear. So we're going to finish with this, and this is what we do in our cases, in that we talk with the educators and on a fact pattern and see what they think. So Paul, can I ask you to start us off with reading this first paragraph, please? This is an actual case.
CS held an Instructional 1 teaching certificate in elementary and early childhood education, and as a reading specialist. In January 1997, she was arrested on charges of endangering the welfare of children, selling, furnishing liquor to minors, and corruption of minors. As these charges involve crimes of moral turpitude, here's a word I don't use very often, PDE filed a notice of charges with the commission and sought suspension of CS teaching certificates pursuant to EDA 5A11. CS requested the commission to grant her an evidentiary hearing in order to present evidence that her husband had filed the criminal charges as part of their contentious and ongoing divorce proceeding. The commission refused to allow CS to present evidence and suspended her teaching certificates on August 11, 1997.
All right, let me just interject here. So she said this isn't a normal criminal charge. And she wanted the commission to know that it was biased and that who filed it, but they wouldn't even hear her. And so, okay, I'll finish. Thank you, Paul. Without her certificates being active, she lost her teaching job. She appealed the commission's suspension of her certificate to the Commonwealth Court, stating that the suspension violated her U.S. constitutional due process rights, in that she said, "You're taking my income, but you didn't listen to how it may be affected." She argued her property rights and employment could not be taken from her without first providing a hearing and a meaningful opportunity to be heard. Without the commission's hearing before the suspension, CS was unable to protect her salary from being cut. The court ordered the commission to give back pay to CS if she was acquitted. And in this case, that's exactly what happened. She was found not guilty of all charges. Her certificate was restored and she returned to work, and she was entitled to back pay to the day that she was suspended.
I was going to say the solicitor for that school district really didn't do his job.
Well, and my only response is that I appreciate everybody sticking with us here. He or she was just following what the law was at the time. And the law was the commission didn't even have to really listen to the educators. So I use that as an example that sometimes court cases make new law and they change the Educator Discipline Act. Thank you.
I have a couple slides left.
Yes.
Say goodbye to you folks. We'll share what we're doing from now on. This is our 5th session, and all 5 have been recorded and will be available on twbaileylaw.com. They're 30 minutes or about 25 to 30 minutes each. And please go and take a look at these 5 areas, kind of introductions to these subjects. They're not full force. Our workshops will take care of that. And speaking of which, twbaileylaw.com, Thomas Bailey's website, sort of a one-stop site for anybody who's looking for some ethics training, and you can get credit for it. Act 48 credit now was recently approved by PDE, a 4-hour course on ethics. And if you are a school system leader or a CTC administrator, we have a 25-hour PIL Act 45 ethics class. And there are also some other kinds of ethics workshops we do. And Thomas has an ethics blog. And as he told you at the beginning of this video, he is going to continue the Tuesday videos. And I think he's going to be talking about some court cases. So for dates, this is the PIL course, September 19th, September 26th, October 3rd, and October 12th. That's 25 hours. And it is PIL Act 45 approved by the PDE. You need to register by September 17th. That's for school system leaders, directors, administrators. And we just announced these dates. They're also up on his website under the events menu. And we're going to start on August 8th during the summer, an approved 4-hour Act 48 continuing education course, 1 hour each day on Tuesdays starting at 4:30. These will meet the PDE Chapter 49 ethics competencies that have recently been released by PDE. So we certainly hope that if you are interested, you will avail yourselves of some of these opportunities by going to twbaileylaw.com.
Thank you, Paul.
Have a good day, everyone.
Take care.